All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon. Ms. Prue has the floor.
Good afternoon, Mr. President, Your Honours. Thank you for giving me the floor. I will continue where my colleagues left off this morning and address 4 issues, as you can see on the slide on your screens. And the topics that I will address today are plagued by the same deficiencies that have been highlighted by my colleagues this morning and by the Yekatom team yesterday. So I will highlight some more of these flaws along my submissions this afternoon, although it will not be possible to address all of it. In any event, we trust that you will undertake a detailed analysis of the parties' submissions as part of your deliberations. So I will start immediately with my first topic, which is the absence of linkage between Mr. Ngai and the group led by Mr. Yekatom, and I will address it in 3 parts chronologically. Your Honours, the prosecution needs to tie Mr. Ngai to the group led by Mr. Yekatom if they have any chance at conviction. Unfortunately for them, the overwhelming evidence is to the contrary. And it bears repeating now that this is not a case of co-perpetration. This is a case prosecuted under Articles 25(3) C and D. And under these modes of liability, the remoteness or the distance between the accused, his contribution, and the crimes means that the prosecution has an obligation to show how that link can be made between the accused and the charged crimes. And the prosecution entirely fails to make this demonstration with regards to the crimes allegedly committed by Mr. Yekatom's group. First, there is no credible evidence that Mr. Ngai contributed, knew, or intended to contribute to the crimes allegedly committed on 5 December and in the immediate aftermath, and which are charged under counts 1 to 6 and 8. There is nothing convincing in the prosecution's closing brief, and they didn't offer anything new in their pleadings this week. In fact, Mr. Belbenoit, who addressed 5 December, did not mention Mr. Ngai once in his submissions. And neither did Ms. Pradaban, who addressed counts 11 to 17. And Ms. Berdenikova mentioned him only twice in passing, but never even tried to link him to the crimes charged under counts 24 to 28. The prosecution's theory of linkage between Mr. Yekatom and Mr. Ngai is flimsy at best. It hinges mainly upon alleged phone contacts that they would have had with common interlocutors, but never with each other. Yesterday, our colleagues from the Yekatom team debunked a lot of the claims regarding the alleged contacts between their client and individuals such as Konate, Mokum, and Angelo, but also Charles Grémangou. And for my part, I will deal with the other side of that claim, and more particularly, the alleged relationship and contacts between Charles Grémangou and Mr. Ngai. Citing Ngai, the prosecution alleges that Grémangou reported directly to Mr. Ngai. That's at paragraph 77 of their brief. But in doing so, they are playing fast and loose with the evidence. Because Mr. Ngai's Rule 68.3 statement does not specify the time frame or the scope of this alleged reporting. And also because during his testimony, Mr. Ngai nuanced this considerably. Ngai stated that there was a meeting in Boeing And that's where he met Grémangou. And he adds, I don't know what role they were playing precisely. I don't know what role they were playing. Which means that at least before that meeting in Boeing, Mr. Ngai didn't know who Grémangou even was or what he was doing. So he couldn't have said that Grémangou was reporting to Mr. Ngai. And indeed, he did not say it at any point during his testimony. Now, the allegation that Grémangou was reporting to Mr. Ngai before 14 January 2014 is also contradicted by the fact that, at least on 9 January 2014, Grémangou was ostensibly acting as president of the CLPC. As president, it's unlikely he was reporting to anyone. And this, by the way, is corroborated by P487, who testified that Grémangou was the head of all the anti-Balaka. Now, while 487 alleged that Mr. Ngai and Grémangou were close, he also said he didn't know the nature of their relationship. So to say, like the prosecution does, that this demonstrates that they were involved with and liaised in the context of anti-Balaka's activities is an overreach, to say the least. The evidence available does not allow to reach such a conclusion. Another example of the prosecution's attempt at creating a link between Mr. Ngai and Yekatom through Grémangou is the allegation at paragraph 241 that Mr. Ngai and Mr. Grémangou were in phone contact ahead of the 5 December attack. Again, there are several issues with this claim. Your Honors, in essence, the attribution of the relevant phone numbers is not established to the requisite standard. First, and as we argued in our response to the prosecution's CDR bar table motion, one of the Cameroonian numbers allegedly used by Mr. Ngai is in contact with another number allegedly used by Mr. Ngai, a Central African number, at least 17 times. Second, and you can see it on the next slide, we recently identified contacts between the two Cameroonian numbers attributed to Mr. Ngai. Third, and it's also in our brief at paragraph 123, we pointed out an instance where these two same Cameroonian numbers are in use at the same time. And you can see this at Annex A12 of our brief and as showed on the screen. Fourth, since the filing of our brief, we continued our analysis and we found 3 more overlapping calls between the two Cameroonian numbers attributed by the prosecution to Mr. Ngai. And we will now show them on the next 3 slides. The first one here on 3 December 2013, second one on 5 December, and a final one on 28 December. So, Your Honors, is it the prosecution's position that Mr. Ngai is repeatedly calling himself, and that he also repeatedly uses 2 different phones at the same time? Well, given the improbability of these scenarios, Your Honors, the only reasonable conclusion is that these attributions are not safe. They cannot be relied on. And by the way, the phone number ending in 8857 that has overlapping calls is the same one that is allegedly in contact with the numbers attributed to Dedan, Maxime Mokom, and many others. And the problems don't stop here, because the same happens for the phone numbers attributed by the prosecution to Mr. Grémangou. All 3 of the phone numbers allegedly used by him call each other. And you see here on your slide the 2 numbers that you see, both attributed to Mr. Grémangou, call each other at least 71 times. And on the next slide, again, 2 numbers attributed to Mr. Grémangou, and they call each other at least 38 times. Your Honors, the prosecution is wanting you to believe that all 3 of these numbers are being used continuously and exclusively by one person. An impossibility in this case. What this shows, at least, is that we cannot know who is using any of these phones at any given time. And this is in addition to the fact that we have no content whatsoever for these alleged contacts. Your Honors, no conviction can safely be based on this evidence alone. And as an aside, I will also highlight that these calls alleged at paragraph 241 of the prosecution's brief between Grémangou and Mr. Ngai were nowhere to be found in the prosecution's pre-trial brief. They were not in the CSTs produced by the prosecution, and they were not mentioned either in the several bar table motions filed during the trial. These calls were never mentioned before the closing brief. And this is telling. What it shows is that the prosecution did not actually give them any weight, that they did not intend to even use them or rely on them, because they knew these calls weren't reliable. They knew they weren't probative. Only now that they are faced with the absence of evidence, with the collapse of their case, now they resort to those in desperation. They throw everything at the wall to see what will stick, if anything. But, Your Honors, even if these calls had taken place between those interlocutors, the prosecution still fails to establish that they constituted a contribution pursuant to Article 25(3)(c) and D. Because not only do we not know what was discussed during these calls, we also have no idea how these calls could have had any impact on the commission of these specific crimes, let alone a significant impact. And this was their burden to meet. They needed to show how these calls constituted a contribution by Mr. Ngai. And they had to show you that this contribution specifically assisted the crimes charged in specific locations and on specific dates. They completely failed to do that. I'll conclude on this point with one more remark. That the consequence of the prosecution's failure to establish any genuine link and substantive interaction between Mr. Ngai and anyone even remotely associated to Mr. Yekatom prior to 5 December is that there is no link between Mr. Ngai and the crimes charged under counts 1 to 6 and 8. There is absolutely nothing of value in the trial record that would allow you to find that Mr. Ngai contributed to these specific charged crimes, that he knew they would occur, or that he meant for them to occur. The prosecution has utterly failed to make this demonstration. And for any remaining issues in relation to these calls, we rely on paragraph 552 of our brief, as well as on the section of our brief dedicated to CDR evidence. I will now move on in time to address the events at Yamara School, charged under counts 11 to 17. And, Your Honors, the same goes for these incidents. And here, in fact, the prosecution doesn't even really attempt to show a connection, because there's a complete void in the evidence. it's not sufficient to allege, like the prosecution does at paragraph 469 and 473, that alleged members of the Goberi group arrived at Yamwara at a non-specified moment in time. Or, like in paragraph 674, that the abductees were released on Grémangu's order. That's not enough. First, and as argued in our brief at paragraph 215, the evidence does not, in fact, establish that Yaguzu was part of the Goberi leadership, or even that he was in Goberi at all. And second, because even if he was, the evidence stops there. There's no suggestion that either Yaguzu or Grémangu or anyone else took instructions, informed, or consulted Mr. Ngai in any way or at any time in relation to these alleged events. There is simply no link between these events and Mr. Ngai. There's no evidence that he did anything to assist the commission of these alleged crimes, no evidence that he could have foreseen them, that he heard about them, and there's no evidence that he could have done anything to stop them. And the prosecution doesn't even really argue that there is. They avoid talking about this entirely, and their silence is louder than words. So here again, prosecution has not met its burden as regards count 11 to 17. Moving on now to the alleged meetings held at Yamwara School in late December 2013. And we address these meetings in our brief, Your Honors, at paragraph 542. Now, the prosecution appears to be relying on emails sent by Mr. Ngai to imply that Mr. Ngai was somehow involved in anti-Balaka activities surrounding those meetings. But in doing so, prosecution completely ignores Ngai's testimony, during which he said that, to his knowledge, Mr. Ngai was not part of the CLPC or of the anti-Balaka, which is why Ngai was emailing him about it. As a former minister, as someone who maybe could help. If anything, the Yamwara meetings and the emails that followed them reinforce the evidence that Mr. Ngai had nothing to do with the movement at that point, but that he was already seen by some as a potential political leader, someone who could help find a solution to the crisis. These meetings also show that there was no coordination between the North and South factions of the anti-Balaka. And that is further confirmed by another meeting, the one that took place at President Samba Panza's residence in January 2014. Now, yesterday, the Yekatom defense very convincingly explained why the prosecution failed to establish a link between the North and South faction ahead of the June 2014 meeting. So I will not repeat this today, but we do agree with their submissions. But now, Your Honors, I would like to touch on two discrete issues in relation to the January meeting at President Samba Panza's residence. And first, at paragraph 112 of the prosecution brief, and again in their submissions on Monday, the prosecution hangs on to the one little bit of P0974's evidence, who said that during the meeting at President Samba Panza's residence, Mr. Ngai allegedly stated that he organized former FACA members from his exile in Cameroon. Now, Your Honors, this is a pretty extraordinary statement. It would have stayed in the mind of any participant in that meeting. That's not something one would forget. And yet, none of the other meeting attendees who testified in this trial, and you have the pseudonyms here on your screens, remembered Mr. Ngai saying that. Not one. And we had no less than 5 other witnesses who attended this meeting, in addition to Madame Samba Panza herself. So that's 6. And tellingly, when Samba Panza was asked to describe what was discussed during this meeting, she did not corroborate P0974. And neither did Mr. Cocaté or P0487, even though these two were very eager to incriminate Mr. Ngai, and they were untruthful on many other aspects of their testimony. And yet, neither of them remembered Mr. Ngai saying this. Plainly put, Your Honors, that's because P0974 was not truthful. Mr. Ngai never said that. And that's why the 6 other witnesses who attended this meeting didn't mention it. Now, the second thing I want to raise about this meeting is the prosecution's assertion that it was Mr. Ngai who invited Mr. Yekatom to it. This is at paragraph 394 and footnote 811 of their brief. Prosecution erroneously refers to the testimony of Samba Panza in support of this allegation. But a cursory check makes you realize that this is wrong. She did not say this anywhere. That's not something she said at all. So this reference is completely wrong. The reference to P0876 is also wrong, because when you look at it, he's speaking about something else entirely, not this meeting. And so are the 2 items of documentary evidence cited. They don't prove an invitation by Mr. Ngai to Mr. Yekatom, not at all. So this assertion is left completely unsupported. And it is also heavily contradicted by reliable evidence that the 2 groups came and left separately. In fact, there is an abundance of evidence that contradicts the prosecution's position. And that demonstrates that not only was Mr. Ngai not the reason why Mr. Yekatom attended the January meeting at Samba Panza's residence, but also that the 2 men didn't have any other interaction until the June 2014 meeting, convened by the Muda NGO. And I refer you to paragraphs 543 and 2457 of our brief for more details on the absence of links between the 2 groups until the eventual merger. So where does that leave us for counts 24 to 28? And I recall that these crimes were allegedly committed on the PK9 Mbaiki axis in 2014, in early 2014. Well, in a word, Your Honor, it leaves us nowhere. There is no evidence whatsoever that Mr. Ngai contributed to any of the crimes charged under counts 24 to 28. And indeed, this whole section of the prosecution's brief doesn't even mention Mr. Ngai. So it took a long detour to arrive at the exact same conclusion as before. There is simply no evidence that Mr. Ngai did anything to assist the commission of these alleged crimes. No evidence that he could have foreseen that these events would take place, that he heard about them, and even if he did hear about them, there's no evidence that he could have done anything to stop them or to punish them. This means, Your Honors, that the evidence does not support the prosecution's theory beyond a reasonable doubt. Mr. Ngai must be acquitted on all counts related to crimes that were allegedly committed by Mr. Yekatom's group. And with this, I will move on to my second topic, which is the Bosangoa crime base. Your Honors, we initially did not intend to address this crime base during our oral submission because our brief very thoroughly reviews the evidence on this crime base. However, in light of the prosecution's submissions on Monday, we felt the need to correct the record on a few issues. And that's because, well, yet again, the prosecution misrepresents, misquotes, cherry picks the evidence, so long as it paves the way for an incriminating narrative. And I will give you some examples on 3 separate aspects. First aspect, I'll be very short on it. It comes out of their brief at paragraph 133. And we're guessing presumably to boost the little evidence that they have, the prosecution alleged for the very first time that the Antibalaka attacked Bosangoa not 2, but 3 times in the fall of 2013. And the first one of these alleged attacks would have taken place between 6 and 9 September. Well, this attack was not addressed by a single one of the witnesses we heard during this trial. No one. No one talked about 3 attacks. They talked about 2. So this means that none of the references that you see in footnote 255 of their brief is actually providing support for that allegation. Prosecution seems to have created this additional attack out of thin air. Second, the prosecution's evidence on the alleged murders on 5 December is equally unconvincing. And we refer your honors to the arguments in our brief, which address those alleged murders in great details. However, now I would like to address some of the most flagrant examples of a negligent assessment of the evidence and a misrepresentation of witness testimonies. The prosecution argues at paragraph 607 that the evidence does not show that armed confrontation took place around the imam's house during the 5 December attack. And for this reason, they ask you to rule out the possibility that victims may have died there caught in crossfire. And in support, they rely on P1577's account of the events leading up to the attack and on P0966's description of the attack. Well, the problem is that in doing so, they ignore a key passage of the evidence of P1577, the same witness that they rely on. Well, P1577 told us that he traveled back to the imam's house to see what had happened a couple of days after the attack. And he took pictures. He testified that very clearly there had been an intense battle, shown by the number of spent cartridges that were scattered around the floor. And his testimony is supported by his own pictures of these cartridges, which were taken just outside of the imam's house and around the area. Your Honors, evidently, there was heavy combat around the imam's house. Your Honors will also recall P0966 testimony and the statement of P2602 on the alleged route taken by Kema's group on the day of the attack, which passes through the Arab neighborhood of Bosangoa. Their evidence further suggests that combat took place in this neighborhood, but the prosecution also disregards them. And I would refer your honor to the annotated map created by witness P0966 during the hearing. And you can find it at CAR REG 00010004, which clearly shows the route taken by the group in launching the 5 December attack on Bosangoa. Now, the dismissive approach of the prosecution vis-à-vis evidence that does not suit its case is again reflected in their argument in support of the alleged death of C-17, also known as C-17 Musa. To try and establish this death, the prosecution persists in relying on the Rule 68.3 statement of P2453 as the only foundation for this allegation. And it's in their brief, paragraph 610, 620, and 635. The prosecution goes as far as to argue that this evidence is direct and unchallenged, thereby completely ignoring the impact of the witness in court testimony. Your Honors will recall the testimony of P2453. The witness told us here in court that no refugee or displaced person was injured when the Antibalaka were close to École Liberté. He testified that he did not see who was shooting at whom, consistently repeating that he did not see anything of the attack. It was in fact so obvious that, Mr. President, you commented that it was a waste of time to continue with this line of cross-examination because it was clear that P2453 was not an eyewitness. And in fact, there was no eyewitness of this alleged death, none. So it's completely false to argue, like the prosecution does, that P2049 and P1577 offer any corroboration. They don't. And this alleged death is unsupported and therefore not established. But the prosecution's willful blind list does not stop here, unfortunately. On Monday, the prosecution showed you what they portrayed as visual evidence of the alleged murders in Bosangoa on 5 December 2013, namely a photo that they obtained from P2049. But, Your Honors, this is false, and they know it. As shown in Annex A18 of our brief, the picture was actually taken at Ali Babolo Mosque in Bangui. And why do I say that they know this is false? Well, because they know their evidence, they reviewed it ahead of trial, and they reviewed it again when they prepared their bar table motions. And indeed, the bar table motion in which the admission of the item you see on the right of the screen was requested. In that bar table motion, they described this as a video taken at Ali Babolo Mosque in Bangui. Now, could it be that they didn't remember that when they wrote their closing brief? Well, maybe, if we want to be very generous. But there is no excuse for repeating this falsehood in this courtroom on Monday, now that we exposed it in our own brief. Your Honors, the reality that they do not want to see is that P2049 was untruthful about this photo, as he was in large parts of his testimony. And there are also paragraphs of our brief dedicated to that as well as an annex. Moving on to another alleged murder. On Monday, the prosecution also argued that it was not established that one of the alleged murder victims, Kursi Abdelhaim, was bearing weapons during the Seleka regime in Bossangoa. They dismissed this as, and I quote, deriving from anecdotes and rumors, lacking specificity. And again, the prosecution buries its head in the sand to avoid seeing the inconvenient truth. Defense witness Odette Ssona saw this with her own eyes, Your Honors. She saw Kursi armed, threatening the local population alongside the Seleka. ND 30-4608 and defense witness Faustin Gamese provide corroboration. These are not rumors or anecdotes, Your Honors. The witnesses called by the defense clearly identified members of the local Muslim population who took up arms and assisted the Seleka in their crimes against civilians in Bossangoa. One of them even saw with her own eyes prosecution witness P2049 carrying a machete. And in the ocean of evidence we have in Bossangoa, we managed to find visual proof. And I refer your honors to Annex A21 of our brief. And a final point about the alleged murders, Your Honor. The prosecution is seeking to convict Mr. Ngai ssona for 2 murders that are not in the charges, namely that of Ousmane Abakar and his mother. Your Honors, these alleged murders were argued before the pretrial chamber, and the pretrial chamber did not confirm them. So in our view, the prosecution is trying to convince you to exceed the scope of the charges. And in any event, Your Honors, the only evidence cited in support of these alleged murders is that of P1577, whose knowledge is largely based on anonymous hearsay. So we respectfully request that you ignore these 2 alleged murders. And I will move on now, briefly, to the alleged rapes in Bossangoa. Now, regarding the counts of rape, the prosecution is misquoting and dismissing evidence again. Here again, Your Honors, the evidence is thoroughly addressed in our brief, so I will limit myself to 2 small points. First, while the prosecution refers to P2602 to try and establish that the alleged rapist of 2462 was an anti-Balaka, it conveniently leaves out the part of the statement where the witness says that this person died and did not participate in the 5 December attack. The reference is in our brief, and this death is corroborated by D30-4608. This kind of cherry picking is misleading, and frankly, it's regrettable. And second, the prosecution again tries to bring up the alleged rape of P2657 within the scope of the charges, but it isn't. The pretrial chamber, declined to confirm this charge, and then you declined to add it during trial. It isn't charged as rape, and it isn't charged as persecution either. And the confirmation decision is very clear on this. The persecution charges in this case are solely based on the alleged conduct pertaining to the confirmed charges. This alleged rape is not one of them. And in any event, and as argued in our brief, It is not established by the evidence available to you, because this evidence is not credible, it's internally incoherent, and it fails to properly identify the perpetrator. And I'll refer your honors to our filing on this issue, filing 2300. Your honors, the prosecution's negligently assessed the evidence and misquoted it repeatedly in the Bosangoa part of their brief as in other parts. The reality is that the witness evidence provided by the prosecution crumbled as soon as it was tested in court. The narrative of the prosecution with regards to events in Bosangoa is a fiction, and we are confident that the chamber will see through it. And I'm moving on now to my third point today, your honors, which concerns the role and limitations of Mr. Ngai as general coordinator of the anti-Balaka movement in 2014. And again, on this topic, the prosecution's propensity to cherry-pick and mislead is particularly pronounced. Reading their brief, it's like we haven't been in the same trial, because they simply disregard the overwhelming evidence in relation to the nature of Mr. Ngaisona's role as general coordinator, and crucially, as to the limitations in terms of what he could actually achieve in this role. Now, given the limited time, I will focus on three main points. And I want to start by addressing the claim at paragraph 272 of the prosecution brief that upon his return to Bangui in January 2014, Mr. Ngaisona rewarded some anti-Balaka members by appointing them as comzones or in other key positions. First, the footnote, it's footnote 551 in their brief. Footnote for that claim contains the same document under 4 different ERNs. So that already gives you an idea of how they struggle to prove their point. And to make things worse, this document that they cite 4 times is the press release dated 14 February 2014 that you have seen several times during this trial, and that does not actually support the claim that Mr. Ngaisona rewarded anybody or appointed anybody to any functions. Now, as is routine in their brief, the prosecution is creating a smokescreen to avoid facing the actual evidence on the record. That is, that comzones were self-appointed. And there's a plethora of evidence supporting this. We refer to some at footnote 2036 of our brief, but there's even more, and you'll see some on your screens now. P1077, P1521, D304756, P808, P889, and P888. These are witnesses from the provinces and from Bangui, most of them insiders, and they all said it very clearly. Mr. Ngaisona had nothing to do with the appointment of comzones. And yet, the prosecution continues to push that false narrative. And the prosecution uses that same tactic at footnote 552 when they allege that Mr. Ngaisona rewarded individuals with positions in the PCUD. Strategically, they refer to one single document as well as to the Rule 68.3 statement of P889. And again, they deliberately ignore that the same witness commented on a similar document in court, stating that several names figuring on purported PCUD members' lists had never, in fact, been members of the PCUD. So to allege that these individuals were promoted or rewarded by Mr. Ngai in his political party is absolutely inaccurate. Prosecution also knows very well that although Mr. Ngai was coordinator from January 2014, he was challenged in this position by several other leaders, including Wenezui, Kokate, Mokom. And his actual sphere influence among anti-Balaka zones and elements was actually very limited. And yet, at paragraph 275 of their any pressure on the zones. They were completely autonomous. You could not give them orders. P808 also added that you could not exclude or expel the zones. They had their weapons. You would expose yourself if you tried. The only way was to try and talk to them and even kneel down and beg them to do the right thing. That's how powerless Mr. Ngai was in front of armed zones. And I will come back to this later in my presentation. And there's more. The evidence on the record clearly shows that Mr. Ngai tried to advise and influence the zones, but that unfortunately he largely failed. Because it was chaos. Because they were armed and he wasn't. In reality, he was a political leader with no teeth. And also because before the June merger, Mr. Ngai did not have any influence in the South faction of the anti-Balaka. So to argue that he could control the zones throughout the country is obviously false. For the same reasons, he could also not punish zones and anti-Balaka members. P889 explained it very eloquently when he said that given that zones were armed, they could punish Mr. Ngai, but Mr. Ngai could not punish them. And that was confirmed by P1521. That Mr. Ngai was even attacked by some zones. He put his life on the line to try and convince them to lay down their weapons. And your honors will remember how several witnesses testified how Angelo attacked Mr. Ngai, shot on his house and tried to kill him, which is an example of the threat posed by the Comzones on the political leadership of the Anti-Balaka. Now, the prosecution also tries to exploit an interview dated 1st April 2014, during which Mr. Ngai is reported as having said that when he gives an order to Anti-Balaka members, there is an immediate reaction. In French, it's je pense que c'est suivi, que c'est immédiatement suivi.
That was immediately followed by consequences.
Je pense, I think. And also, we have to understand this statement in its proper context. By April 2014, Mr. Ngaisona's leadership was contested left and right. Chaos was reigning in Bangui and elsewhere, and he was trying to get the Anti-Balaka movement under control. This was a political statement. Was his advice to Comzone followed? Well, as the evidence shows, largely not. So whatever he said exactly in that interview, this statement does not comport with reality. And a statement that doesn't reflect the facts cannot reasonably be used to establish the truth. And that brings me to speaking of that term, general coordination, or national coordination, and what this meant exactly. Because the prosecution speaks about it as if it was a formalized, a hierarchical, a functioning structure. And they say at paragraph 298 that Mr. Ngai in 2014 continued to set up a proper structure of the national coordination. And then they refer to a chart that was drawn by witness P1521. And that chart, they take it at face value. But, Your Honors, in doing so, they again mislead. P1521 explained very clearly that the chart he drew was only what it should have been in theory, but that in reality, it was never respected. He unequivocally confirmed that there was no hierarchical rapport within the structure of the coordination, and that the political head of the coordination could not control the comzones or elements on the ground. The prosecution completely ignored that in their brief. And they similarly ignored the corroboration provided by P889, who went even further when he testified that the coordination only existed on paper. And then they ignored more corroboration provided by P808, who stated that this organizational chart is only something in theory. But, Your Honors, this just doesn't suit the prosecution, so they pretend this evidence does not exist. And since they ignore all this, well, they persist in also alleging, paragraph 314 and 352, that Maxime Mokom reported to Mr. Ngai. But this is not the case. P808, again, explained that the reporting line was purely theoretical, but it was not applied in reality. He confirmed that Mokom had his own agenda and was acting autonomously. P889 corroborated this. Mokom did not report to Mr. Ngai ssona. Ngai ssona did not report to Mokom. And so did more witnesses, other witnesses, and you see some of that on the screen now. From P1521, P888, P1858, and on the next slide also from P1193. But that evidence is nowhere in the prosecution's brief. It's like this never happened. Now, it is also wrong to assume, like they do at paragraph 352, that Mr. Yekatom reported to Mr. Ngai ssona at any point before June 2014, and that Mr. Ngai ssona had any authority over Mr. Yekatom. And I will not repeat the reasons why. It's in our brief, and our colleagues from the Yekatom defense convincingly explained this in their oral submissions yesterday. So here again, to wrap up on this point, in reality, what is the national coordination? Well, it's a bit of a pompous name for what was essentially an attempt at bringing some structure to a movement that had none. Structure that could have brought more calm, less chaos, but it was never, in fact, much of a success, and for several reasons. Well, first, because chaos had just taken over the country in early 2014. Also because the help that Mr. Ngai ssona requested from the transitional government and international forces never materialized. Because resources were scarce, but the needs were vast. And also because some individuals, like Mokom, had a different agenda. So you could call it a failure, but one thing you cannot call it is a hierarchical organization with effective reporting lines, because the evidence provided by their own witnesses shows the contrary. And I will now move on to my fourth issue, which is the issue of knowledge and criminal intent. I will not surprise you, Your Honors, when I say that, again, the prosecution failed to meet its burden. Now, as you know, Articles 25(3)(c) and D represent the lowest forms of responsibility available under the statute. They cast the wider possible net. And for this reason, the requirements for mens rea are more demanding and more specific. For 25(3)(c), we even speak of an elevated mens rea. And that is clear from the Bemba et al. Case and also the more recent Al-Hassan judgment. Article 25(3)(d) is similarly demanding, and the applicable case law before this court stipulates that general knowledge is insufficient, but that the accused must be aware of the group's intention to commit each of the specific crimes to which he is contributing. The prosecution knows that the evidence available in this case does not allow them to demonstrate the mens rea to the required threshold. So what they're trying to do is lower the bar. It's to convince you that you don't really have to apply any rigor to your analysis. And this transpires throughout their brief, and in particular through the pages that they dedicate to Mr. Ngai ssona's knowledge and intent. You will note that they say, for example, at paragraph 309 and 315, that Mr. Ngai ssona knew that the Antibalaka would commit the types of crimes charged. Note, not the specific crimes, only the types. Because as we've discussed at the beginning of my presentation, there's no evidence that he knew about any specific crimes charged, that he knew that they would be committed. So they're trying to lower that standard. They're arguing, without although saying it expressly, and against the clear jurisprudence of this court, that a general intent is sufficient. Another example at paragraph 318 is when they argue that these types of crimes happened before in the Central African Republic, so it was common knowledge that they would be committed again. Your Honors, it's hard to unpack how much prejudice is contained in that statement. The prosecution is basically telling the Central African people that it's common knowledge that they are uncivilized, and it's common knowledge that they are prone to violence and cruelty. So everyone should and must have known that this would happen again. This is an unfortunate statement, to say the least. And despite how inflammatory this allegation is, it still falls short of the standard they had to meet. It still doesn't show that Mr. Ngai was aware and had the intention to contribute specifically to the crimes charged. And then another tactic they use is simply to relitigate the alleged contribution. They repeat, rephrase, rehash the same things over and over and over again, as if it made it more convincing. Also, they resort to making highly incriminating conclusions without any reference. No footnote, no evidence, nothing. Just their opinion, unbothered by evidence. And I will now delve into more details, starting with the alleged knowledge and intent of Mr. Ngai in relation to the alleged 2013 events. Prosecution for 2013 heavily relies on press coverage to try and prove that Mr. Ngai was aware of alleged attacks against Muslim civilians during the fall of 2013. And also that this knowledge should have been a warning for him to stop his alleged contribution and to walk away. We heard them say that several times this week. He should have walked away. And the fact that he did not proves his criminal intent. At paragraphs 147 and 348 and 349, for example, they refer to a number of newspapers, TV reports, or UN and NGO reports. But when you look closely at these sources, you'll realize that several of these are CAR newspapers, to which Mr. Ngai would not have had access during his exile. Others are reports or articles in English, a language that Mr. Ngai does not speak or understand. And others, again, were published much later, so they would not have been available at the time. And that's the case of the video that the prosecution showed on Monday, which they used to say that Mr. Ngai must have been aware of the Boali attack when it took place. And they showed car OTP 2012-0523. Well, this TV report aired nearly 6 weeks after the Boali attack of 3 December, as per the metadata available. So clearly, it could not have been a warning about the 5 December, like the prosecution argued on Monday. Actually, only a handful of the documents cited could potentially, theoretically, have been read or seen by Mr. Ngai at the time. But there's no evidence whatsoever that they were. Now, going back to the alleged Boali attack, and it's at paragraphs 223 to 225 of their brief, prosecution implies that Mr. Ngai must have known that crimes were committed against Muslim civilians in Boali because other witnesses had heard about it. And they cite three. They start by P. 1847, who said he heard it on the news. But what 1847 said he heard was about, and I quote in French, braquage,
hold-ups and mishaps by Muslims and burnt vehicles.
The prosecution is alleging. Then they refer to P. 0884, who was in Boeing at the time, so relatively close. He was in the country, at least. And he said he heard about the attack on the local radio and that it was common knowledge. Now, I will allow me an aside, Your Honors, because if we'd had €1 every time that a witness told us something was common knowledge, we would all be rich. Let's face it, in most cases, that's nothing but a fancy expression for rumors. And then the third witness they cite is D304848, who explained that soldiers were paying close attention and that it was also discussed on social media. But again, there's no evidence whatsoever that Mr. Ngai had access to the same news, that he listened to the same radio broadcasts. That a handful of witnesses heard about it doesn't mean that Mr. Ngai did. Five years ago, the pretrial chamber set the standard that the prosecution should meet with regards to the use of media reports, in particular with respect to proving that such reports reached Mr. Ngai. Well, they have made no progress. They are still incapable of demonstrating that these news reports actually reached him, that he actually heard about these specific events, and that he heard about it in time for this to serve as a warning. So nothing has changed since the confirmation decision. Going back to Boali, they also refer to Facebook commentators, and I will not delve into that because it does not engage Mr. Ngaisona's knowledge whatsoever. And we have actually already spoken at length today about Facebook, and it's also dealt with in our brief. One last thing on the same Boali attack. Finally, the prosecution also mentions an email allegedly received by Mr. Ngai on 4 December, informing him of this attack. But presuming that the email is actually authentic, did Mr. Ngai read it? Or did it maybe fall in the spam folder and went unnoticed? But if he did read it, when did he read it? And even if he did read it on the 4th of December, these emails did not mention Muslim civilians being killed. So how can the prosecution jump to the conclusion that it could not have reasonably escaped Mr. Ngaisona's attention that Muslim civilians were targeted during the Boali attack? This is a jump that nothing in the evidence allows them to do. And about this common knowledge of attacks in the provinces in general, it's worth recalling that when P1521 was asked by the prosecution about the 5 December attack on Bosangoa, he said he'd never heard about it. This is a person who was part of the Anti-Balaka and was part of the coordination later in 2014, and he'd never heard about an attack, this attack in Bosangoa, before being asked about it in court. So to say that everybody knew about all of the attacks taking place in the provinces in 2013 is not accurate. The prosecution has to prove that knowledge with regard to Mr. Ngai, and they fail to do that. And I will move on now because the remainder of the prosecution's argument regarding Mr. Ngaisona's knowledge in 2013 essentially just relitigates the contribution, and we've addressed this at length in our brief and again this morning. But before moving on to 2014, I just want to contrast the prosecution's theory that Mr. Ngai was fomenting anti-Muslim animus throughout 2013 with his own words during an appearance in Markunda near the Chadian border on 13 March 2013. Now, the context is as such. This is on the eve of the coup. Seleka is approaching, and he is speaking in an area which, by virtue of its proximity to Chad, has an important Muslim population. And he tells the audience that they only have one country, that they must be artisans of peace and security. He asks the audience to remain optimistic, to exchange and reflect, to promote a culture of peace, tolerance, work, and development. There is not a hint of anti-Muslim animus in that speech. And that's pretty much the last public statement given by Mr. Ngai until January 2014. Now, others might have, at some point of time, expressed anti-Muslim animus. We're not denying that. But Mr. Ngai did not. Even at the height of the crisis, even as the Seleka was approaching, he called for peace. He called for unity. He called for reconciliation. And he continued to do so with remarkable consistency throughout the period of the charges and thereafter. Now, seeing that the 2013 evidence led them nowhere in terms of proving Mr. Ngaisona's criminal intent, the prosecution had to resort to his actions and words in 2014. But no luck to them. The 2014 evidence only reveals the extreme weakness of their case in that regard. And as I recalled earlier, under Article 25.3 C&D, the prosecution needs to show that Mr. Ngai lent his assistance with the aim of facilitating the offense. And that's where the prosecution's theory hits a wall. Because there is a vast amount of evidence showing that any steps taken by Mr. Ngai in 2014 to structure the Antibalaka, to advise them, to feed them, to advocate for them, was taken with only one aim in mind: the return of peace. Your Honors, the prosecution is essentially asking you to look at the words and actions of Mr. Ngai in 2014 and assume, take for granted, that they were in bad faith. That's the only angle they have, because on their face, they do not demonstrate criminal intent. So they twist, they distort and misinterpret. And they are asking you to do the same. There's one big obstacle, Your Honors, and that's the presumption of innocence. And that's why you cannot follow them down that path. You cannot, like them, assume that Mr. Ngai was advocating for peace as a sham, as a way to conceal crimes. And in any event, there's a vast amount of evidence that this wasn't the case. That he was, in fact, genuinely pursuing peaceful objectives. And I will now go a little bit deeper in what the prosecution is alleging. First, the prosecution uses any reference to Seleka crimes by Mr. Ngai or others as proof that Mr. Ngai was trying to stir the desire for revenge. Now, there are several issues with this. The first being that in 2014, the Central African people were still shell-shocked by what they had just been through. Several witnesses during the course of this trial told you that the level of violence inflicted by the Seleka on the civilian population was unlike anything they had ever experienced. So in 2014, in the weeks and months after the Seleka finally departed, this was very much on everybody's mind. They were still reeling from it. Now, to acknowledge the victimization of the Central Africans is not stirring a desire for revenge. To portray it as such is reductive and offensive to the victims of the Seleka. The prosecutor should be embarrassed. Also embarrassing is the fact that in support, they could only cite a document requesting billeting of anti-Balaka elements that was sent to the president's office in February 2014. So by definition, not a document that you can stir anything with, not a document that was accessed by the simple anti-Balaka elements. And then they cite a statement given by Mr. Ngai in September, well outside of the charge period. That's at paragraphs 324 and 325. Other than that, they cite other people, not Mr. Ngai. Now, why don't they cite him more? Well, because if they cited his words more, they might have to acknowledge that aside from recognizing the victimization caused by Seleka crimes, he also repeatedly called to lay down weapons, to respect the Muslim population, to reconcile, to foster social cohesion. And well, Your Honors, they don't want to draw attention to that. They also falsely allege that Mr. Ngai referred to Central African Muslims as Boko Haram. That's at paragraph 333. And this claim was recycled from their pretrial brief, without regards to the evidence that unfolded in the meantime. Now, when you look at Mr. Ngaisona's words in their context, it's very clear that he is asking for members of the armed group called Boko Haram to be disarmed. Because Boko Haram was present in PK5. President Samba Panza told you that they were, and so did another witness who also testified here. And the references are at footnote 2061 of our brief. Second, the prosecution also alleged that the fact that Mr. Ngai was part of the coordination is an indication that he condoned violence against Muslims. That's essentially the point they're trying to make at paragraphs 337 to 342 of their brief, again drawing on the words of other persons. In essence, the prosecution is telling us that associating with the anti-Balaka movement in 2014 is enough to infer criminal intent. That Mr. Ngai should have walked away, and the fact that he stayed shows that he condoned the commission of crimes. And now here again, the prosecution is taking shortcuts and avoiding to address facts in their proper context. And the context is as follows, and was described by several witnesses. It was chaos. When Mr. Ngai returned to Bangui in January 2014, and for the months that followed, there was no rule of law, no functioning state authorities, no police, no gendarme, no national army, no judiciary. And in that power vacuum, yes, you had generalized criminality. Crimes that were committed by a variety of perpetrators. Civilians, Christians and Muslims. Seleka elements who were still present. Members of the 11 other armed groups circulating in Bangui and in the provinces. fake anti-Balaka and also real anti-Balaka. The prosecution is trying to have it both ways, alleging that Mr. Ngai was implicitly aware that crimes were being committed, that's at paragraph 316, and later alleging that Mr. Ngai denied that anti-Balaka were committing crimes. So is he admitting or denying? Can't be both. Well, in reality, Mr. Ngai never denied the commission of crimes by some anti-Balaka members. Rather, he acknowledged it and took measures within his powers to stop them. And you can see an example of this on your screens. It's not denying crimes to point out that people other than anti-Balaka members were also committing them. And that's why, Your Honors, that's why Mr. Ngai repeatedly asked for help with ID cards to identify the culprits. That's why he repeatedly advocated for billeting, to separate armed persons from civilians. That's why he helped set up the military police, to try and arrest perpetrators, disarm them, and hand them over to the authorities. That's why he repeatedly asked the anti-Balaka to lay down their weapons. That's why he housed and gave money to feed some of them. And I want to remind you that President Samba Panza did the same for the same reasons. That's because he was trying to restore some level of order amid the chaos. Because armed men with a roof over their head and food in their bellies are less likely to go ransack, to go steal. And a myriad of witnesses came here and attested to this, to the fact that these measures were favorable to the return of peace, that they had a positive impact, and that they were taken by Mr. Ngai with genuine intentions. Now, would we in this courtroom make that same decision and stay in the movement in face of the impossible situation that was prevailing in 2014? Maybe not. Maybe we wouldn't. Maybe we would walk away. But that this man stayed and tried to improve the situation despite all odds does not make him a war criminal. And to the contrary, several witnesses attested to the fact that it would have been worse without him there. That the country benefited from his decision to not walk away, to not abdicate responsibility. So the prosecution can assume bad faith. They can cherry pick and distort Mr. Ngaisona's words as much as they want. It will not change these facts. Which brings me to the ludicrous allegation that Mr. Ngai tried to obstruct the efforts of the transitional government and international forces and failed to disarm the anti-Balaka. That's at paragraph 380 and following, and again in their submissions on Monday. Well, Your Honors, the case record is replete with evidence of the exact opposite. From the moment he returned to Bangui, Mr. Ngai did not stop asking for help and disarming, which is, do I need to say it, an element of the DDR which he was advocating for relentlessly. And you have one example on your slide now. And the words that you see on the screen, Mr. President, are clear. Mr. Ngai is asking the anti-Balaka to disarm, to let international forces do their work, to let them arrest criminals, to back off, to return to our villages. Your Honors, there is no other possible interpretation of these words. we have to evaluate Mr. Ngaisona's words and actions in their proper context, and that what were his ability, what was possible for him to do at that point. And that's really the crux of it. Because when the prosecution is reproaching Mr. Ngai for not disarming the Antibalaka, are they actually suggesting that he should have physically removed their weapons from them? Because that was never a possibility, and they know that. So what the prosecution is accusing him of, in fact, is to not have achieved the unachievable. They're setting a standard for him that was always out of his reach. Now, I'm being told I'm short on time, so I'll cut quickly, but you see a document at the next slide. Prosecution alleges that Mr. Ngai rejected the government suggestion to have the Antibalaka return to their provinces, citing this document, which demands exactly that. So we'll pass rapidly on this. They also say he did not investigate crimes, but they never explained to us how he would have had the power or the means to investigate the crimes, him not being the police, not being an authority in this country. And yet, he helped create the military police to try and take some responsibility, try to take some actions to make a difference. And they reproach him for that too. Several witnesses spoke about these efforts, about how upset Mr. Ngai was when he heard that Antibalaka committed crimes. Prosecution also says that Mr. Ngai imposed no sanction, even though they say he had the power to do so. And they refer to the decisions excluding 2 political members of the Antibalaka, 2 unarmed individuals with purely political functions. Well, that's, again, quite misleading, Your Honors. Now, we'll recall that several witnesses came here and told us that Mr. Ngai had no way of sanctioning or excluding persons in arms, be they zones or Antibalaka elements. And you see some of that on your screens now. Paragraph 400, the prosecution is blaming Mr. Ngai for inviting zones to meetings and to the Brazzaville Forum, which they allege reinforced his acceptance of their conduct. Now, not only is the prosecution ignoring the pretrial chamber's findings on such arguments, but also ultimately this argument begs the question, what does the prosecution think that peace negotiations like the Brazzaville Forum are for? Because in our understanding, peace negotiations are for exactly that, for bringing belligerents around a table to discuss a way out of the crisis. So they are the ones who could or not make the violence stop. These are precisely the people that needed to be invited to the negotiating table. And that was also the understanding of P889. So far from being an acceptance of their conduct, it's a sign that Mr. Ngai knew that these were the ones that needed to be educated, that needed to accept to lay down their weapons, to convince their elements to comply. You don't make peace with just politicians and diplomats. You make it with the people in arms too. So to conclude on the alleged mens rea, Your Honors, faced not only with the absence of direct evidence, but also with the overwhelming amount of contrary evidence, the prosecution resorts to blurring the distinction between the general criminality prevailing in 2014 and the specific crimes Mr. Ngai is charged with. I have explained to you earlier in my presentation why the link between Mr. Ngai and the charged crimes is not established. And then I explained how Mr. Ngai genuinely and actively tried to curb the criminality in the Central African Republic, regardless of perpetrators, civilians, fake Antibalaka, or real Antibalaka. And the problem here is that the prosecution subsumes one into the other to try to hide the lack of evidence linking Mr. Ngai with the charged crimes behind the evidence of mass criminality. As a result, they're effectively trying to hold Mr. Ngai responsible for all of it, indistinctively. So this goes against the scope of the charges. It goes against the presumption of innocence and against all principles of criminal justice. Mr. Ngai cannot and should not be held accountable for all crimes committed during that period. To the contrary, the evidence shows that Mr. Ngaisona's words and actions were aimed at preventing crimes, at preventing violence. And that's why the prosecution is scrambling the way that they are. That's why they misquote. That's why they avoid citing large parts of the evidence on the record. Simply put, we have passed the point of reasonable doubt here. We are in front of a gaping hole in the prosecution's theory. And we submit that a reasonable trial chamber could not come to the conclusion that Mr. Ngai harbored criminal intent. Very quickly, in conclusion, Your Honors, the prosecution case has entirely collapsed. They have investigated for 10 years, interviewed hundreds of people. They carefully selected the witnesses whom they thought were the most incriminating. All this just to have these persons, one after the other, telling the truth that Mr. Ngai was a man of peace. And Mr. van der Poel sarcastically said on Monday and Tuesday that this is something that the defense came up with, that we are pushing this narrative against the evidence. Well, that's not correct. It didn't come from us. It came from the prosecution witnesses. And here you see 2 slides with that expression exactly. And there's a lot more on the record. It was said with many different words. Prosecution witnesses also testified that Mr. Ngai relentlessly advocated for the end of hostilities, promoted reconciliation, assisted the Muslim community, protected Muslim civilians, and so on. And now the prosecution is trying to convince you that this only happened because the defense interfered. But you know, as we do, that this was already written on the wall long ago. It was in the statements they took in 2016, in 2017, in 2018, long before there was ever a defense team. And yet, the prosecution went ahead with this case like a deer in headlights. This week, the prosecution told you that the testimonies of insider witnesses alone were sufficient to sustain a conviction, because you would know how to discern where these witnesses minimized their responsibility or their involvement to protect the accused out of loyalty or out of fear or pressure. Between the lines, what they're asking you to do is to dismiss any evidence that these witnesses gave that was favorable to Mr. Ngai. They ask you to believe these witnesses only when it suits them and their theory, and disregards the rest. But any holistic evaluation of the evidence must take into account the exculpatory evidence on the record. This evidence must be viewed and weighed appropriately, not just dismissed as an inconvenience. Because that's where the doubt lies, and that there's doubt everywhere in this case. The presumption of innocence requires that this doubt benefits the accused. Your Honors, it's not your job to save the prosecution's case from bringing down the standards and presuming guilt rather than innocence. In this case, the prosecution is indeed asking you to presume that Mr. Ngai had a criminal intent. That's because it cannot be deduced or drawn on the basis of the evidence. To the contrary, the evidence shows that Mr. Ngai, through his actions and words, was a man of peace, acting with reconciliation in mind only. Now, the victims of crimes committed by all sides in the Central African Republic deserve that the right persons be held accountable. And these persons are not in this courtroom. Justice is rendered by a fair process and a fair outcome. And in this case, for this man, it must mean an acquittal on all charges. With your leave, and I know I took a long time, but I would like to yield the floor back to Mr. Knops briefly for conclusion. Thank you very much.
Thank you, Ms. Brewer. I think Mr. Knops will keep it short.
Mr. President, thank you very much for giving me the floor to close on behalf of our team. Mr. President, I would ask the Chamber to take the following citation into consideration. It's a citation from the late Reuben Carter, a black boxer in the 60s, who was wrongfully incarcerated for 20 years for a triple murder in New Jersey in 1966. In 2014 he died, but he left a very important legacy. And the legacy is the following. Every officer of the court is ethically bound to the truth, but not every officer of the court can resist the urge to further his or her career with a string of convictions, whether or not these convictions comply with the truth. It is precisely when winning or losing becomes the be-all and end-all that truth is disregarded and justice becomes elusive. End of quote. The Chamber have heard throughout the last couple of years and also today from our defense team the potential devastating effects if someone, an officer of the court, cannot resist the urge to further a conviction. It might even transpire into the independence of experts, like what happened in this court with P2926, who, after writing 4 drafts in his final report, increased the incriminating observations on Mr. ssona from 18 references to 41, upon request of the prosecution. You can find it in T39 in our brief, paragraph 40. Your Honors, we all here in this courtroom, we all bear the responsibility to clearly separate between what we know and what we imagine, to navigate through the noise, to navigate through the speculation, the assumptions, and to ultimately distinguish between truth and fiction. Gossip masquerading the evidence has no more merit than blurred voices echoing in the corridors. Therefore, associations, accusations built on speculation must crumble under your fair and legal scrutiny. Mr. President, the court, as we hope, cannot turn a blind eye in the absence of direct evidence against Mr. ssona. No hate-infused rhetoric, no traceability of money and weapons, no rallying presence in the field. Not a single witness stood up to say that he was there. In the realm of justice, the criterion of reasonable doubt is the only fierce guardian against wrongful convictions, Mr. President. We trust in your sincerity and your professionalism to navigate through these obstacles. Your Honors, we pray that your judgment is led by fairness and not by misconceived preconceptions, perceptions, and various speculations as was put forward in this case. Mr. ssona and his family demands nothing less than an acquittal in this case, for the evidence falls woefully short of sealing the fate of an innocent man. Mr. ssona didn't look away from the suffering in his country. He came back to Bangui, and as Ms. Sambapanza said, the social cohesion between the Muslims and the non-Muslims was, I quote, à tout l'honneur de M. ssona, T251. That were the words of a court witness. He did not look away, Mr. President, from the suffering in his country. and he asked the court not to look away from the reality of the evidence. Thank you very much.
Thank you, Mr. Knops. This concludes the hearing of today, and this concludes also the judicial year, so to speak, for this chamber. And on behalf of the chamber, I would like to thank you, parties and participants, members of the registry and the interpreters, for all their efforts they have made during this year. The court is adjourned.
All right, veuillez vous lever.